May I please, Your Lordship?
Yes.
I have filed a MSc appeal. May it be listed today, my Lord.
No, not today.
Only a notice to the delay. I will take only 2 minutes of Your Lordship. Only notice to the delay.
Tomorrow. MSc appeal, there is no urgency tomorrow.
Yes, my
Okay.
Lord, since I have come.
Yes,
back-
next.
Okay.
Next, Lordship.
Yes, please.
Lordship, I picked mention item 15, 1.5. Lordship,
Ah.
for respondent number 2.
Yes.
My senior Mr. Limawapang is not keeping well, Lordship. So if Lordship maybe
Mr.
wishes not
Procedural,
to grant 2
Learned
weeks,
Council
Lordship.
submits that. Mr. Limawabang, the Learned Council for the respondent number 2 is indisposed. And 6, adjournment of the case after a week.
2 weeks, Lordship.
After
Thank
2
you.
weeks. Prayer is allowed, listed accordingly. Okay.
My lord,
Are you obliged, Lord?
my lord, I am appealing for the petition.
Okay.
May I have a date, my lord, on 5th of August, if not inconvenient?
Mr. Svensson, Learned Senior Counsel appears for the petitioner. When do you want it?
5th of August, if not inconvenient, my lord.
Listed on
5th of August.
5/8/2024, not after 2 weeks, okay?
Are you obliged, Lord?
Yes.
Well, the interim order passed earlier, may continue.
The interim order passed earlier shall continue till the next returning date. Okay.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 14 on behalf of V. Devnath. He is out of station. So kindly list the matter after vacation. Lordship,
MS Svensson. Learned Counsel makes a mention on behalf of Mr. V. Devnath, Learned Counsel for the petitioner, and seeks adjournment of the case after a week.
vacation.
By this honorable court order dated 3/05/2024, the applicant was supposed to deposit 50% of the total awarded amount before the registry of this court. But due
Okay.
to the-
Cancel the order, let it come as per the list. We'll see.
Maybe, Your Lordship, I'd
Yes.
like to mention for hearing item number 12. Lordship, my senior is feeling unwell. Kindly this.
Who is
matter-
your senior?
IMT launcher.
I am Longcha. MS so makes a mention on behalf of Mr. IMT Longcha, learned counsel for the petitioner, and seeks adjournment of the case after
2 weeks.
2 weeks. Prayer is allowed, listed accordingly. Okay.
Lordship, I have a similar prayer with item number 13.
13,
Yes, Lordship.
MT Longcha, same.
Lordship, for item number 18, the senior counsel is from Oxide, he's in Shillong, so kindly list the matter.
Senior
After
counsel
submit-
for petitioner or
Yes, Lordship, petitioner, Sohor Ali
who is the
Sheikh.
senior counsel?
Sohor Ali Sheikh, Your Lordship.
MS so item 18. Learned counsel makes a mention on behalf of Mr. Sohar Ali Sheikh, the leading counsel for the petitioner, and seeks adjournment of the case after
Summer break.
2 weeks.
Lordship.
Prayer is allowed, listed accordingly.
Obliged.
Your Honor, if I may,
Lordship, I beg to mention items 16 and 17. Lordship, my senior is indisposed, so kindly list this after 2 weeks.
Young Arwati,
Yes, Lordship.
young Arwati.
Yes.
Understand, so. Learned counsel makes a mention on behalf of Mr. Young Arwati, learned CGC, and seeks adjournment of the case after
2 weeks, Lordship.
2 weeks. Prayer is allowed, listed accordingly. Yes, Mr. Tito. Yes.
Your Honor, if I may, item number 7 and 8. I am the petitioner number 2.
Yes.
I would like to request for a 1-week adjournment.
MS so and so. The petitioner in person seeks adjournment of the case for a week. Prayer is allowed. This is item
Thank you,
6,
Your Honor.
item 7 and 8. Prayer is allowed,
7 and 8, Your Honor. Yeah.
listed
Thank
accordingly.
you, Your Honor.
For motion, item number 19.
Yes, Mr. Joshua.
Yes, Your Lordship.
What is this IA for?
Your Lordship, by this IA, I'm asking for the alteration of and/or modification of the order dated 19/3/2024 passed by the Honorable Court, granting interim stay to the appellants.
What is wrong with the order?
Your Lordship, here, the
Which is that
reason,
order? Where?
Annexure A, Your Lordship,
Annexure A, page 15.
my lord.
Page 15.
Yes, Your Lordship.
Yes, what is wrong with the order?
Your Lordship, may kindly appreciate this fact,
Ah,
that the learned court district judge Zinepato, Your Lordship,
uh,
passed the interim order dated 30/9/2022 in favor of the present applicant. It was a challenge to the judgment of the Dobashi Court dated 2011/2021. The Dobashi Court District Customary Court, Dobashi Court, Zinepato, Your Lordship, passed a judgment in a case of a property dispute between a lady and the present applicant, Your Lordship. Now, Your Lordship, the right to inheritance in the village property was also granted by the Dobashi Customary Court, Zinepato, which is unknown to the semi-customary law, Your Lordship. The immovable properties, inherited properties, Your Lordship.
Okay, what is the
Yes, Your
procedural illegality?
Now, Your Lordship, after the interim order dated 30/9/2022 was passed in favor of the present applicant, the present appellant,
Where is that order?
Your Lordship,
Passed in your favor? Where is that order?
my lord, it is in the Your Lordship may kindly come to the civil revision petition, Your Lord. Yes, the civil revision petition, Your Lordship.
Page.
My lord, I'll show Your Lordship. Page 85 of the revision petition, Your Lordship. Annexure C.
85.
May I read, my lord?
Yes, wait, yes.
Order
Yes.
dated 13/9/2022, receive an appeal petition under Rule 31 of the Rules for the Administration of Justice and Police in Nagaland, read with Section 96 of the Code of Civil Procedure 1908, against the order dated 2011/2021 passed by the DB's customary court Zinemoto, from Shri Mahatwej Kinimi through the Learned Counsel so-and-so advocate. The main submission of the Learned Counsel for the plaintiff is that the order dated 14/3/1990 passed by DB's court VK has never been challenged or set aside by any court and has attained finality. He further argued that the DB's court Zinemoto not only committed a grave error in law, but also adopted a procedure unknown both in modern law as well as customary law by directing the village to divide the properties land between Taishe, Hevshe, and Litapu clan. Learned Counsel also submitted that as per the Naga customary practices, women are not entitled to inherit any ancestral property, nor the GB ships. However, the DB customary court Zinemoto passed the order against the Semi-Naga customary law with the without following the due procedure. Learned Counsel also prayed for staying the order dated 2011/2021 passed by the DB's court Zinemoto. I have heard the Learned Counsel for the appellant peruse an appeal memo and its annexure from page 41 to 59, and on being satisfied, appeal is admitted and registered as civil appeal number 1 of 2022. Having heard the Learned Counsel for the appellant Sri so-and-so, and after careful consideration of projection made in the application, I am of the considered view that the appellant has been able to make out a prima facie case for interference of the impugned judgment in order dated 2011/2021 passed by the Dabashi Customary Court Zinemoto. However, keeping in view of the established cardinal principle of natural justice, it would not be fair to draw my conclusion at this age without giving a chance to the opposite party in view of the matter. It is provided that till next returnable date, operation of the impugned 2011/2021 passed by the DB's customary court Zinemoto shall remain suspended. It is needless but made clear that the opposite party shall make sure that counter-written statement by affidavit is filed so that the final hearing can be done and the case be disposed at the earliest. Issue notice to the opposite party. List this matter after 4 weeks. However, the maintainability of the present appeal shall be considered only on the outcome of the case number civil revision petition number 81 of 2022, Mr. Kevizati Sesa versus State of Nagaland and 4 others presently pending before the Honorable Chief Justice of the Gauhati High Court. Copies of this order be issued to all the parties for compliance. Issue copy of the order along with so-and-so. The appellant shall take steps for the service of someone notice to the respondent within 1 week. Fixed on 21/10/2022. Then, Your Lordship may kindly.
What is this CRP 81/2022?
Your Lordship, the matter which is still pending before the Honorable Court is whether from the decision of the Ganburas and the Dabashi Customary Court, whether the civil court will have the jurisdiction to take it on appeal or not under the rules for the administration of justice and police in Nagaland. That is still pending, Your Lordship.
The petition before the district court
Yes, Your Lordship.
will also be subject to the outcome of
Yes,
that petition.
Your Lordship. But at the moment, it is still pending, Your Lordship. Now, my Lord, will kindly appreciate this. Annexure D, my Lord, may kindly come to page 88. May I take Your Lordship to page 89, in the course title. An application under Order 39 Rule 4 CPC for setting aside order dated 30/9/2022 staying the operation of the impugned judgment and order dated 2011/2021 of the DB's Customary Court Zinemoto. Your Lordship, it was an appeal petition filed before the district and session judge Zinabuto, district judge Zinabuto, Your Lordship. So on appeal, it is Order 41, Rule 5, where the operation of the impugned order is interfered with by the appellate court. CPC Order 39 has got nothing to do with the appeal petition, Your Lordship. So when this application was filed under the wrong,
For that matter, even the appeal application under this Rule 31 is subjudiced.
hello,
Under Rule 31 is subjudiced.
Rule 41.
31. Appeal under Rule 31.
Hello.
The appeal under Rule 31 before the Debauches Court, before the district court,
My Lord.
against the judgment passed by the Debauches Court, is also subjudiced.
Oh, my Lord, in that sense, since there is a clear possibility that it may lead to abuse of the process of law, where when the appellant before the learned court below, district judge, my Lord, the present applicant, if he has no place to go, Your Lordship, to take his grievance, Your Lordship, that subjudice may not amount to contempt, Your Lordship.
No.
So in a case where,
Provision under this Rule 31
my Lord,
is before the Deputy Commissioner's court, not before the district court.
no, Your Lordship, as far as the cases that this honorable court has already adjudicated upon in years, the appeal has always been lying before
The matter is
district judge,
subjudiced
Your
before
Lord.
the principal state.
Even otherwise, Your Lordship.
Not even otherwise, that the issue will not rise.
No, my Lord may kindly appreciate this aspect. Now, when the present applicant, if he has no court to approach, then in the process, if the property is
He has
divided,
avenues under Rule 31. Rule 31 is before the Deputy Commissioner of a district. He could have actually made the appeal under Rule 31 before the Deputy Commissioner.
it was a case referred by the Deputy Commissioner, Your Lordship. A case referred to the
So
DB's customary court.
a case referred by Deputy Commissioner to DB's court. DB's court has decided the matter. The person aggrieved by the DB's court order can always approach Deputy Commissioner in appeal. Simple as that. Anyhow, we'll issue notice. Let us hear the other side also.
Your Lordship, since that subject matter is still under dispute. I
That's
do-
what I'm
yes.
saying. That is why it is under dispute, it is subjudice. So it may not be proper for this court to enter into that subject. That is exactly what this court is.
But my Lord will kindly appreciate this. When the stay is already granted and the other party comes under the wrong provision of law, on appeal, it is Order
So
41, my
we will
Lord.
hear,
Yes, Your Lordship.
we will hear the application. Heard Mr. Joshua Shaki, Learned Counsel for the applicant. Stop. The application has been filed under Chapter 5A, Rule 7-A, within bracket, Clause 2 of the Gauhati High Court Rules 2022, read with Section 151 CPC, praying for modification and or alteration of the interim order dated 19/3/2024. And the subsequent orders 19/3/2024 passed by this court. Granting interim stay of the orders dated 30/9/2022 and 19/12/2023 passed by this,
The district judge is never to be lost.
passed by the district judge Zaneboto. Stop. Issue notice to the respondent, to the sole respondent, returnable after 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the sole respondent by a registered post with AD within a period of,
My lord, registered post.
yes, registered
Have we
post
not
with
served the
AD
copy? My
within a
lord,
period of,
2 days, my lord.
within a period of 2 days
My lord,
from today. Okay.
oblige your lordship.
For motion, item number 22.
Yes, Mr. CT.
May I place your lordship? This is the second round of litigation.
Okay.
Matter relates to appointment of medical attendant in the primary health center, Cherry.
Wait, medical
Uh,
attendant.
During the pendency of the first writ petition, an order was passed by this honorable court. Lordship has passed an order on 9/6/2022 directing the deputy commissioner to verify with regard to the land ownership that is under clause 3, subclause P of the notification of 5th March 2018. So pursuant to the direction passed by this honorable court, the deputy commissioner has verified and found that on the basis of that verification, government has also filed an affidavit. And in the affidavit, it was found that yes, the petitioner is the legitimate landowner and they have not availed any benefit. That was the report. Basing on that, an order was passed by this honorable court, passing the order of the appointment of respondent number 5 and directed the state respondents
In
to,
that case,
yes, advertise the post with a clear condition that the preference should be given to the landowners. That was the categorical
where is that
observation.
observation? Where is that observation?
That observation, Lordship will find at page 54. But then the operative portion, Lordship will find at page 66, paragraph 27.
Page 54? That is
That
the
is
judgment.
Yes,
That is the
judgment.
judgment.
That is the judgment. This is ordered at 30th May 2023. And operative portion, Lordship will find
Yes, wait.
from
Yes.
and operative portion, Lordship, kindly come to page 66, paragraph 27. Page 66, paragraph 27. Lordship will find in the bottom of the page. May I read this operative portion, Lordship, so that it will be clear. May I read, Lordship?
Yes, please.
Paragraph 27. In view of what has been discussed herein above, the state respondents are directed to publish an advertisement following the guidelines of the Honorable Supreme Court of India in the state of Odisha versus Mamata Mohandi for filling up the vacant post of medical attendant Chari, giving option to all the eligible candidates to apply for the same, and thereafter a proper selection process should be held wherein the petitioner and respondent number 5 may also be allowed to participate if otherwise found eligible. This is very important. In 2 occasions, this honorable court has said that the petitioner's claim for preferential treatment on the basis of land ownership may also be considered by the respondent authority in the said recruitment process. Mention about such a preferential treatment on the basis of land ownership may be made there in the advertisement itself. This was a categorical direction and this was not complied with, Lordship. This does not preclude respondent number 5 from applying to the post in terms of the advertisement to be issued by the respondent authorities if she is otherwise found eligible to apply for the same. So this is very important. even if the respondent number 5 is allowed to participate in the selection process, that is subject to if she is found eligible to apply for the post. Now, she belonged to a different district. As per the latest office memorandum of the government, the indigenous inhabitant of the particular district are eligible to apply for the post. So the baby respondent number 5 is not eligible also, but the manner how the advertisement has been issued by the respondent authorities is issued in a very critical manner so as to avoid the preferential treatment of the landowner.
Where is that advertisement?
Advertisement, Lordship will find at page 69, type copy. Nowhere in the advertisement they have mentioned about
Page
this.
68.
Page 69. 68 is the original, but the type copy is more clear. Lordship will find it page 69, the type copy. As many as 6 conditions were given. The observation in paragraph 27 made by this honorable court for giving preferential treatment to the landowner is not mentioned in the advertisement. Therefore, the order passed by this honorable court has not been complied with, although in the advertisement itself, in the first paragraph, Lordship will find this is in compliance to the Honorable High Court's Kohima bench judgment and order dated 30th May 2023, passed in WPC number 122 of 2019. So they say that this has been done in terms of the order passed by this honorable court on 30th May 2023. But as I have just pointed out to your lordship, the condition for giving preferential treatment to the landowner has not been mentioned, in spite of the fact that there is a clear direction by this honorable court on the order of 30th May 2023 about granting preferential treatment to the landowner.
Let us
That is
come,
how
let
I'm
us come
agree.
back to the order. Let us come back to the order.
Yes, page 66. Operative portion, lordship will find to save time. Let us go to page 67. From the second line, we can see a proper selection process should be held wherein the petitioner and respondent number 5 may also be allowed to participate if otherwise found eligible. The petitioner's claim for preferential treatment on the basis of the land ownership may also be considered by the respondent authority in the said recruitment process. Mention about such a preferential treatment on the basis of land ownership may be made there in the advertisement itself. So it is very, very clear, lordship, that this particular observation of this honorable court has not been complied with, not inserted in the advertisement. That is how I am aggrieved, because there is a reasonable suspicion that they may proceed with the selection process and the landowners will be left out, and this observation of this honorable court will be rendered redundant, lordship. It will become meaningless. So the fruit of litigation will not be enjoyed by the petitioner. Lordship, may kindly again come to page 40. This is an order passed by a lordship, and relevant portion is page 43. A direction has been issued by this honorable court to the deputy commissioner to verify about the landowner, which has been done, and consequent upon all this process has been done, and ultimately this honorable court has passed an order giving a preferential treatment to the landowner, but that condition has been left out in the advertisement. So I have reasonable suspicion that they have some ulterior motive so as to consider the other candidates. If it is left open to all, then there will be no point.
Mr. C.P. Daman, the Legislative Council. Assisted by M.S.
Krobit Sekro.
Learned Counsel for the petitioner. Stop. New para. The case of the petitioner in brief is that he is one of the landowners where the present primary health center Chari has been established and is therefore eligible to be considered to a grade 4 post on the basis of land ownership. Earlier, the petitioner has filed WBC 122/2019 impugning the appointment of one Achimla S. Sanctum as medical attendant, Chari Primary Health Center, doing some Nagaland. Stop. This court, by the judgment and order dated 35/20/23, while setting aside the appointment of the respondent number 5 therein, as medical attendant PHC Chari, had observed that the post of the medical attendant Chari be advertised in accordance with the constitutional scheme as held by the Honorable Supreme Court. In state of Orissa versus Mamata Mohanty. In the said judgment and order, the finding was also given that the petitioner's claim for preferential treatment on the basis of land ownership may also be considered by the respondent authority in the state recruitment process and mention about such preferential treatment on the basis of land ownership may be made in the advertisement itself. Consequent to the judgment dated 35/20/23 passed by this court in WPC 122/219/2019, the government of Nagaland, Directorate of Health and Family Welfare, Nagaland, Kohima, has issued the advertisement dated 21/6/2024, inviting applications from indigenous inhabitants of Toengsang district to fill up one post of grade 4. Within grade 4, within bracket medical attendant. At PHC Chari. Stop. Mr. C.T. Jamia, the Learned Senior Counsel submits that. Although the advertisement dated 21/6/2024 is purported to have been issued pursuant
Attachment dated 35.
to the judgment dated 35/20/23 passed by this court in WPC 122/2019. The findings given by the court in the said judgment that the preferential treatment on the basis of land ownership may be considered and mention about such preferential treatment on the basis of land ownership may also be made in the advertisement itself is not found incorporated in the advertisement dated 21/6/2024. Stop. And therefore, the advertisement dated 21/6/2024 has not been issued in accordance with the judgment and order dated 35/2023 passed by this court in WPC 122/2019. Stop. Therefore, the present writ petition. Issue notice to the respondents, returnable after 4 weeks.
Lordship, a short time may be issued because considerable time has already been lapsed. 1 year has already gone. Immune order passed by the Honorable Court was 30th May 2023. Advertisement issued after more than a year. That too a defective advertisement. So, Lordship is
Returnable
issued
after 3
notice,
weeks.
3 weeks and
3
then
weeks.
it is a simple case. The order of this Honorable Court is very clear.
Returnable
So,
after
endeavor may be made to dispose of under returnable. Let them
returnable
get
after 3
instructions.
weeks. Mr. K. Angami, the Learned Senior Government Advocate appears for the state respondents. Therefore, no formal notice need be issued. Stop. The Learned Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Learned Senior Government Advocate within
2 days.
within a period of 2 days from today. Stop. In the interim, considering the submission made by the Learned Senior Counsel and the case and the facts and the circumstances of the case, this court is inclined to grant interim stay of the advertisement dated 21/6/2024, passed by the government of Nagaland, issued by the government of Nagaland, Directorate of Health and Family Welfare, Nagaland, Kohima, till the next returnable date. Stop. And an endeavor shall be made by the parties to dispose of the case on the next returnable date. Okay.
For admission, item number 1.
My sincere apologies, Your Lordship.
Yes, Mr. Joshua.
In the item number 19, the registered posts will not be required, Your Lordship, because they are represented by a council, so I can directly give it to them.
Okay, okay. What was that order passed in, this is item 1.
Item number 19, my lord. Motion
Item 19. What was that order passed? So far as notice is concerned? No, you, learned counsel for the, you cut that. Since Mr. Enangami.
I'm
for-
They are represented by councils in Dimapur who are residents of Dimapur. This is between two
No,
private
no, no,
parties. Your Lordship.
in that case, you take steps. For
So, Your
such-
Lordship, they have filed a civil revision petition number 4 of 2024.
Anyhow, you're filing IA, so notice has to be served.
Yes, my lord,
But
but
they serve
not through
notice.
registered post, Your Lordship, because they are already represented in the case. I'm filing an IA in an existing case, my lord. So registered post, Lordship, that will take time for the parties to even receive also, Your Lordship. So since they are already represented by a council, allow me to serve it to the
Mr.
council, my lord.
In that paragraph, okay, notice paragraph. Mr. Joshua, the learned counsel for the petitioner shall serve the copies of the IA to Mr.
The last order? My apologies, Your
No,
Lordship.
this is government.
No, Your Lordship. State is not a part.
Then why is state? Or just was. Mr. Joshua Shakti, the learned counsel for the petitioner, for the applicant,
My apologies, Your Lordship.
shall serve the
Mr. P. Suryan.
shall serve the requisite copies of the application to Mr. P. Suryan,
My lord.
the learned counsel for the petitioner, for the
revisionist, Your Lord.
for the revisionist in civil revision 4/2024, correct?
My lord. Yes, Your Lordship. And my lord, within 2 days, my lord.
Within 2 days from today.
My lord, may kindly allow me to request this honorable court to allow.
You are
to maintain
revisiting your
status-
case.
Status quo, Your Lordship. At least a status quo, my lord.
No, we will hear and dispose once and for all, since there is already an interim order granted by this court.
The status quo is on today, my lord.
Yes,
Lordship.
For admission, item number 1.
May I please, madam?
yes, Mr. Nangami.
Lordship, on the last occasion, this honorable court has asked me to get the up-to-date information with regards to the matter. If I may be allowed to make a short submission, your lordship, on this.
Have you received the instruction?
Yes, your
Then
lordship.
what is your instruction?
Lordship, the oral verbal instruction. What happened is, your lordship, the petitioners is seeking extraordinary pension. Now, the state government has already granted the extraordinary pension to the petitioner. That is who happens to be the wife of the deceased government servant, your lordship, way back in 2012. Now, the pension paper was processed to the Accountant General Office, your lordship. However, the Accountant General Office has returned back the documents or the pensions document on the ground that the deceased government servant is not a regular government servant. However, that is not a family pension, but it is an extraordinary pension. Now, extraordinary pension need not, it says that the government servant need not be a regular government servant. And therefore, the state government have granted the extraordinary pension to them. Now, challenging that letter issued by the Accountant General Office, your lordship, the petitioner are here before this court by filing this particular writ petition, your lordship. In the meantime, your lordship, the Accountant General Office, your lordship, has filed an affidavit, lordship, wherein by a letter, Your Lordship, dated 30/1/2024, they have asked the Home Department, who is the parent department of the deceased government servant, to resend the pension papers, Your Lordship. Now here, Your Lordship, what happened is, during the time when in 2012, when the state government have granted the extraordinary pension to the petitioner, it was granted to the wife of the deceased government servant. Now, Your Lordship, the wife of the deceased government servant remarried in 2013. And therefore, in this writ petition, Your Lordship, the minors of the deceased government servant is seeking the extraordinary pension. Your Lordship, the government is taking that into consideration and is also allowing the minor children to, though it was not granted to them, but the government is taking that into consideration. In the meantime, Your Lordship, the form of the pension papers has to be changed, because in 2012, what has been submitted to the Accountant General Office was in the name of the wife, not the children's, Your Lordship. So a new pension paper has to be submitted now, Your Lordship. Now, the new pension paper, Your Lordship, as to the information given to me by the Home Department, is that the new pension paper has already been asked to the petitioner to take it out and then submit it again in the name of the children's now, which the petitioners are yet to submit to the department, Your Lordship. Not only that, Your Lordship, the last pay certificate, LPC, is under process, Your Lordship. So these are some of the steps which are delaying, Your Lordship. In fact, the government are taking steps, but
Mr. Nizol,
the Lordship.
you file a short affidavit on the instructions received by you, so that the petitioner will also be aware of what she has to do.
Lordship, in fact, this morning also they are already aware. It seems that their client yesterday, they came and took all the documents from their chamber to submit it to the department. That is what they have admitted this morning, Your Lordship.
So, if the petitioner has taken all the documents from you, is it?
Yes,
Is it
Lordship,
so?
yesterday, the petitioner went and submitted to the secretary, that is Home Commissioner, to the Commissioner and Commissioner and Secretary Home yesterday. So, Lordship, I
You
believe
take some
sometime
time,
may be
you take
given,
some time
Yes.
to get instructions,
sometime may be given to the government.
not to the government, to you. To you,
Uh,
you take instructions and come, since you have already, your client has already taken all the papers from
No,
you.
Lordship, we are waiting for the LPC certificate, which was to be furnished to us. After that, the AG also said that they will process the pension papers, but they are waiting for the LPC certificate, which was to be furnished by the Secretary.
Along with the LPC certificate, Your Lordship, the forms of the pension form also has to be processed to the AG. Now, the LPC is under active consideration, Your Lordship. That will not take time. The Home Department have different branches, Your Lordship. Now it seems that I'm told that the LPC, it has been sent to the appropriate branch, and they are awaiting that, Your Lordship. Once they get that, Your Lordship, along with the pension papers, they will send it to the Accountant General Office.
So
Yes,
who-
it
who-
won't
who-
take time
who-
as
who
far
is
as
to
the
place the instructions? If that is your instructions, you will have to file your affidavit,
Lordship.
because as per the last order, up-to-date instructions.
Yes.
And your instruction seems to be quite lengthy. So in oral, that too,
Yes, Your Lordship.
So you file your affidavit on the instructions received,
Okay, Your Lordship.
okay?
Lordship.
So that they may also be aware what is happening in the department.
Lordship.
Okay.
Lordship.
Mr. N. Angami, the Linas Senior Government Advocate, submits that oral instructions have been received from the department. Stop. This court, however, desires that oral instructions received by the Linas Senior Government Advocate may be placed on record in the form of an affidavit, listed after 2 weeks. We
Lordship.
give it 2 weeks.
Lordship.
Okay.
Lordship. I'm obliged, my lord.
For admission, item number 2.
Item 2. Yes, Mr. Taka.
Lordship, the affidavit filed by the respondent number 8, Deputy Commissioner Kohima, I just received inside the courtroom. Lordship, I did sufficient time to verify whether the,
Whether that is there on record, ma'am? When did you file?
6/2024.
26, just wait, okay, 26, 2024.
Yes,
Okay, 26, 2024.
yes, yes.
This is the affidavit on behalf of
R8.
R8.
so my lord, kindly grant me 4 weeks' time. I need to verify all the land documents, whether verification has been done in terms of the direction in the file and reply.
Mr. Takamasa, the Learned Senior Government Advocate.
General Senior Counsel.
Oh, I'm sorry, the Learned Senior Counsel submits that he has received the affidavit in opposition filed on behalf of respondent number 8 only recently,
Just now, Lordship.
only today, and would therefore like to go through the same. And would therefore like to go through the affidavit in opposition filed on behalf of the respondent number 8 to properly address the court.
Lordship. And the benefit of a reply, Lordship, rejoinder affidavit. Affidavit in reply. Because I would,
And to properly address the court and to file reply, if so advised.
yes,
Listed after,
4 weeks, Lordship.
listed after, okay, listed after 4 weeks.
Obliged, Lordship.
For admission, item number 3.
Item number?
May I please, Lordship?
Yes.
Lordship, I've sent affidavit to get signature from the deponent, but it hasn't written it.
You are for?
I'm for respondent number 3, private respondent.
And madam, have you filed your affidavit? Have you filed your affidavit? Okay.
Lordship, 2 weeks may be granted, Lordship.
Mr. Swenson, learned counsel for the respondent number 3 submits that the affidavit in opposition of the respondent number 3 has been sent for signature and is awaited. And therefore 6 for 2 weeks' time. Prayer is allowed.
Your Lordship, if I may be allowed to file my reply, Your Lordship, as well, to the affidavit filed by the state response, Your Lordship.
State respondent, Mr. M. Solo, learned counsel for the petitioner, is also permitted to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Much obliged. For admission, item number 4.
Lordship,
Yes.
I have filed my wakalat nama on behalf of the respondent number 6. I am appearing for the first time, the Lordship, and I
Respondent number, just wait, respondent number,
6, the private respondent, Lordship, whose appointment is under challenge.
okay.
It's a short matter, Lordship. I may be kindly granted 3 weeks to file my counter affidavit.
Have you filed your, this thing?
I've already filed. State has filed.
Mr. Cynthia Amber? Learned counsel submits that he will be representing the respondent number 6. And to that effect, he has filed the power.
Hello.
The learned counsel accordingly 6 for 3 weeks' time to file affidavit in opposition on behalf of the respondent number 6. Stop. Prayer is allowed. Listed accordingly.
Obliged,
Yes.
Lordship.
For admission, item number 5.
Lordship, here I have received the affidavit in opposition filed by the respondents, Lordship.
Okay.
I may kindly be granted 2 weeks to file my reply.
Okay. Mr. Sintiamar, the learned counsel for the petitioner is allowed 3 weeks time to file reply to the affidavit in opposition filed by the state respondent,
No,
filed
the
by-
junior, Lordship, by the respondents.
filed by the respondents. Prayer is allowed, listed accordingly.
For admission, item number 6.
Yes. Mr. Ma,
Yes, I have received the instructions, but I'm seeking some papers. So there's a release of pending bills,
yes,
the case of the petitioner. So I pray that I need to allot some time. so
if it
that-
is admitted, give.
Your Lordship,
If you are admitting the pending bill, give it.
no,
You are not admitting.
there is some defect.
There is some defects. Okay. Mr. Moimchan.
My lord,
The-
let it come after vacation.
Okay, Mr. Moimchan, the Leonard Senior Government Advocate submits that he has received the instructions, but he needs further clarifications and seeks for 3 weeks' time. Listed accordingly.
Obliged, Lord. Obliged.
For admission, item numbers 9 and 10.
Yes. None appears for the petition. Petitioner listed after 3 weeks.
For admission, item number 11.
Please, Your Lordship.
Yes.
Your Lordship, as per the court order 36/2024, we have already served an issue notice to the respondent number 5 who said.
3/6,
36/24, Your Lordship.
respondent 5.
Yes, Your
Who is R5? Have you, by what means you have served the notice?
Through the Lavana, Your Lordship.
What about registered? The learned counsel for the petitioner shall take fresh steps for service of notice upon the respondent number 5 by a registered post as well as by usual process within a period of 7 days from today, listed after 3 weeks. Take fresh steps, okay?
For hearing, item number 14.
Yes, what is this 14 MSC? By which order, ma'am?
305/2024.
35/2024.
03.
Which order? 30,
No, 0305/2024.
03/05/2024.
Yes.
03/0. No, no order to that effect has been passed.
No, it's in IA.
Which IA?
IA 38 of 2023.
IA?
38 of 2023.
What is that IA? IA? 38 of? Yes, where is the deposit?
Lordship, as per the instruction, the person who used to sign the check has been transferred. So the new person is yet to join. So we will be depositing the amount before vacation.
Before vacation?
Yes, Your Lordship.
If not, we dismiss the appeal on that condition. Okay?
Yes.
You pass in the main MSc appeal one. Okay? Heard MS, your good name, please.
Ayala Imchin.
So and so, learned counsel for the appellant and MS. So and so, learned counsel for the,
Appellant.
oh, you are for the appellant.
Yes,
MS.
Your Lordship.
Maybe MS so and so, learned counsel for the appellant and MS so and so, learned counsel for the respondent claimant. Stop. By the order dated 3/5/2024, passed in IA within brackets civil 38/2023. It has been ordered that the award dated 29/8/2022, passed by the learned member MSCT Mugukchung in MSC case number 18/2019 shall remain stayed, subject to the condition that the applicant/appellant deposit 50% of the total awarded amount before the registry of this court within 4 weeks from the date of the order. Stop. Today, when the matter is listed, MS so-and-so, learned counsel for the appellant, has submitted that the person who is supposed to sanction,
Who is supposed to sign the check?
the person, the official of the insurance company who is supposed to sign the check is,
Transferred.
has been transferred.
Yes, Your Lordship.
And a
then-
new incumbent has taken over charge
Yes.
and therefore 6 for 10 days time to comply with the order dated 3/5/2024 by depositing 50% of the awarded amount or of the amount which has been awarded by the learned member MSCT Mokchung in MSC case number 18/2019. Stop. Considering the submission made by the learned counsel for the appellant, the case is again listed on 10, okay, 10/7/2024. Stop. It is made clear that if the deposit is not made as ordered on 3/5/2024, this court shall consider passing necessary orders, including dismissal of the present appeal. Okay.
So
Over. Mr. Angami, can you kindly just come on?